Hello everyone, this is your host Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. The Supreme Court bench of Justices Abhay S. Oak and Ujjal Bhuya delivered a crucial judgment today, limiting Enforcement Directorate's power to arrest an accused after the special court has taken cognizance of the complaint. It has held that ED cannot arrest an accused using its powers under Section 19 PMLA after the special court has taken cognizance of the money laundering complaint. This section empowers ED officers to arrest an individual without a warrant. If ED needs custody of the accused for further investigation, it must apply to the special court. The special court, after hearing the accused, will decide whether custody is necessary or not. The court also clarified that the ED could arrest another person not named in the complaint if the requirements of Section 19 are met. Further, it has been held that once a complaint is filed under Section 44 Clause 1 Subclause B of PMLA, then procedures from Section 200 to 205 of CRPC will apply. Section 44 deals with the offences triable by the special court, and Section 200 to 205 of CRPC outline the procedures for dealing with complaints and appearance of the accused in court. The judgment says that if the accused was not arrested before the complaint, the special court should issue a summons rather than a warrant. If the accused complies with the summons, it is not considered as being in custody, and bail conditions under Section 45 of PMLA do not automatically apply. If the accused fails to appear, then the court may issue a bailable warrant first and, if necessary, a non-bailable warrant later. To read this in detail, you can visit livelaw.in. Coming to the next important update, the bench comprising Justices Sanjeev Khanna and Dipankar Datta today continued hearing Delhi Chief Minister Arvind Kejriwal's petition challenging his arrest by the Enforcement Directorate under the Prevention of Money Laundering Act in connection with the alleged Delhi liquor policy case. Last week, as you know, the court allowed the release of Kejriwal on interim bail till 1st June for the purpose of election campaigning. Today, Solicitor General Tushar Mehta objected to the maintainability of the petition filed by Kejriwal. He said that the remedy of bail under Section 45 of PMLA could not be bypassed by filing a petition under Article 226 or 227 of the Constitution. The Solicitor General said that Section 19 PMLA has certain inbuilt safeguards against arbitrary arrests, and that violation of conditions for arrest could be examined only by the trial court. He said that in the present proceedings, Kejriwal was calling upon court to conduct a mini-trial over the subjective satisfaction of the investigating officer regarding the necessity of arrest. The bench, however, observed that Kejriwal did not bypass procedure and had in fact approached the trial court first. There was also a discussion in the court today about whether the Enforcement Directorate officer can ignore materials favoring the accused while exercising the power of arrest. This was in context of the argument raised by Kejriwal that ED ignored witness statements supporting him and selectively chose incriminating evidence to arrest him. On this point, Additional Solicitor General S.V. Raju argued that the satisfaction of the officer under Section 19 is purely subjective and it does not require that all materials have to be reflected in the reasons to arrest. Further, during the hearing, the ASG asserted that there was evidence to show that Kejriwal demanded a bribe of 100 crores, which went to the Aam Aadmi Party for Goa election expenses. The ASG also said that apart from vicarious liability as the head of the Aam Aadmi Party, Kejriwal is also directly liable as the person who played a key role in formulating the excise policy. When the ASG argued that the arrest is also corroborated by subsequent evidence, Justice Khanna commented that material should be sufficient prior to arrest, and ED could not rely on post-arrest material. The hearing in the matter will continue tomorrow. Stay tuned. Coming to another update on the Delhi liquor policy. The Delhi High Court today issued notice on the plea filed by BRS leader K. Kavita seeking her release and challenging the entire proceedings leading to her arrest in the corruption case registered by the CBI related to the alleged liquor policy scam. Apart from entire proceedings leading to her arrest, Kavita has also challenged the trial court order allowing the CBI to interrogate her while she was in judicial custody. It was her case that the order was passed without issuing any notice to her. Kavita has also challenged the trial court order granting permission to the CBI to arrest her as well as the orders remanding her to police and judicial custody. Issuing notice on her plea, Justice Swarnakant Sharma listed the matter for hearing on 24th May. ED has alleged that Kavita, along with other members of the South Group, conspired with top Aam Aadmi Party leaders and gave them kickbacks and in exchange got undue favors in formulation and implementation of the excise policy. The Supreme Court today adjourned the bail plea of activist and Bhima Koregaon case accused Jyoti Jagtap to July. Today, the matter was before the bench of Justices M.M. Sondaresh and S.V.N. Bhatti. However, when it was called out for hearing, the bench expressed its inability to finish the hearing today. Jagtap has challenged the order of the Bombay High Court, which rejected her bail application. She has been lodged in jail since September 2020 for offences under Unlawful Activities Prevention Act after being arrested in connection with the 2018 caste-based violence that broke out at Bhima Koregaon in Pune and for having alleged links with the proscribed far-left outfit Communist Party of India Maoists. The hearing was today adjourned to July, keeping in mind the summer vacations. Similarly, another matter was today postponed to July, that is the cash for job scam and Senthil Balaji's bail plea. MLA and former Minister V. Senthil Balaji has approached the Supreme Court against a Madras High Court order denying him bail in this money laundering case. He faces allegations of organizing the collection of money for job promises within the department along with his personal assistants and brother. Numerous complaints were filed by candidates who paid money but did not secure employment. Based on these allegations, the Enforcement Directorate arrested Balaji in June last year. Today, the bench of Justices Abhay S. Oak and Ujjal Bhuya postponed the matter to July after Solicitor General Tushar Mehta sought an adjournment as he was occupied in another matter. According to the Constitution, writ petitions under Article 32 can be filed only against entities considered as state under its Article 12. This includes various government bodies and authorities that perform public functions, ensuring accountability and protection of fundamental rights against misuse of power by state actors. In this regard, a judgment was pronounced by the Supreme Court observing that the writ petitions filed by employees against Air India Limited would no longer be maintainable due to its subsequent privatization. Let me tell you, the petitions here had raised issues related to non-promotion and stagnation in pay. In 2022, the Bombay High Court had held that the writ petitions, although maintainable on the dates they were instituted, had ceased to be maintainable by reasons of privatization of Air India Limited, which takes it beyond the court's jurisdiction to issue a writ or direction to it. Thus, the concerned employees preferred an SLP before the Supreme Court and challenged the High Court order. Last year, the top court had issued notice in the instant petition and the verdict was delivered today. During the hearing, senior advocate Sanjay Singhvi, appearing for the petitioners, had submitted that writ petitions, when filed, were admittedly maintainable. He further added that the rule that admissibility of a case should be based on circumstances present at the time of the petition was filed should generally not be changed. On the other hand, senior advocate Dr. Abhishek Manu Singhvi, representing Air India Limited, had appraised the bench of several orders passed by various high courts across the country where petitions against Air India Limited had been disposed of as non-maintainable due to the subsequent privatization of an entity which was earlier a state under Article 12 of the Constitution. The bench of Justices B.R. Gawai and Sandeep Mehta has now dismissed the appeals and confirmed the High Court order. The Supreme Court today issued a criminal contempt notice to Delhi Development Authority Vice Chairman in the matter concerning the rampant felling of trees in Delhi's Ridge Forest area in violation of its previous orders in MC Mehta versus Union of India. The bench, comprising Justices Abhay S. Oak and Ujjal Bhuya, during the last date of hearing had passed a detailed order expressing displeasure about the manner in which the entire exercise of tree cutting was done in Delhi Ridge area without permission of the court. Previously, the court had asked the DDA vice chairman to submit an affidavit stating that he would restore the entire area where the trees were felled. Today, after perusing the affidavit, the court was not satisfied with the averments made in the affidavit and termed the entire exercise as criminal contempt of court. The court reprimanded the DDA officials for misleading the Lieutenant Governor of NCT of Delhi, who holds the position of chairman of DDA. DDA was also directed to stop all further activities for road construction and also to visit the site to verify the same. The Supreme Court has today directed the Union government to take immediate steps for deporting 17 declared foreigners detained in transit camps of Assam. The bench of Justices Abhay S. Oak and Ujjal Bhuya gave this direction considering that no pending cases were registered against them. The bench was hearing the matter pertaining to condition of detention centers in Assam, where individuals with a doubtful citizenship and deemed foreigners are kept in detention. Previously, the Assam Legal Services Authority Committee was directed to visit the detention centers and ascertain the number of foreigners detained for 2 years and subsequently form a committee to investigate the facilities being given to them. The report regarding the number of such foreigners was submitted, but the report on the facilities in the detention center was not furnished. The court took note of the report and that there are 17 declared foreigners detained in the detention centers of the transit camp, out of which 4 have spent more than 2 years. The court ordered the immediate deportation of 17 such declared foreigners against whom no criminal charges were pressed, and that priority should be given to deport the 4 persons who had spent more than 2 years in the detention center. The court also questioned if there was a deportation treaty with the neighboring country or any existing procedure to facilitate deportation. Relying on Supreme Court's order granting interim bail to Delhi Chief Minister Arvind Kejriwal to campaign for the upcoming Lok Sabha elections, the Punjab and Haryana High Court has granted interim bail to Punjab's former Forest Minister Sadhu Singh Dharamsot, arrested by the Enforcement Directorate in connection with a money laundering case. He was booked under Prevention of Corruption Act and the IPC over alleged irregularities in state's forest department and disproportionate assets. He was arrested in January this year and after ED custody was sent to judicial custody. Justice Vikas Behel observed that Dharamsot does not belong to the ruling party and is not holding any public office and thus is not in a position to influence any person or tamper with official files. It was further noted that the petitioner had responded to every summons issued by the Enforcement Directorate and had not skipped any summons. And lastly, an update from the Calcutta High Court, which today declined an urgent hearing for a plea seeking the court's intervention into claims that victims of rape in Sandeshkhali were being threatened and forced to withdraw their complaints to the Central Bureau of Investigation. The court had earlier transferred the probe to the allegations of rape and land grabbing by former TMC strongman Shah Jahan Sheikh to the CBI and had directed it to hold confidence-building exercises in order to obtain complaints from the locals. Today, the bench of Chief Justice T.S. Sivangnanam and Justice Hirannamai Bhattacharya were informed that women were being threatened in the area and that people covering their faces were entering their homes, threatening them to withdraw their complaint. Noting the submissions, the court stated that the CBI was in control of the issue and that the petitioner would be free to approach the CBI to allay their grievances. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.